panelists here this evening. To my immediate right is Mr. Doug Ende, who is with the Washington State Bar Association and works in ethics issues with the Washington State Bar Association. Very pleased to have Mr. Ende with us. Next to Mr. Ende is Judge Vicki Hogan of the Pierce County Superior Court, a member of the Ethics Advisory Committee, and thank you so much to Judge Hogan for being with us tonight. Next to Judge Hogan is Mr. Roger Wynne, who is an assistant city attorney for the city of Seattle, the section director for land use at the city attorney's office, and an adjunct professor at Seattle University Law School, and a member of the Ethics Advisory Committee. And down at the end of the table, Mr. John Erlick, Judge John Erlick of the King County Superior Court, and also an adjunct professor at Seattle University School of Law and a longtime expert in the issue or the matter of judicial ethics, serves on the Commission for Judicial Conduct, the Commission on Judicial Conduct, former member of this committee, the Ethics Advisory Committee, and the chair, I believe, of the Superior Court Judges Association Judicial Ethics Committee. So thank you so much to our panelists for being with us tonight. We're going to just have our panelists make some brief presentations to you on various issues, and then we'll entertain questions. Just wanted to say a word about our very capable and able staff of the Administrative Office of the Courts. In the back of the room is Ms. Nan Sullins, a distinguished attorney and with the Administrative Office of the Court, staff attorney to the Ethics Advisory Committee, and Ms. Caroline Paz, also with the Administrative Office of the Courts, provides outstanding staff support for the Ethics Advisory Committee as well. Just a word or two about the Ethics Advisory Committee itself. This is a committee that was established by the State Supreme Court under General Rule 10. It's a 7-person committee consisting of one member of the Court of Appeals, that is now Judge Linda Lau of the Court of Appeals from Division 1. There are 2 Superior Court members on the committee, that would be myself and Judge Hogan. And we have 2 judges from courts of limited jurisdiction, and at present they are Judge Jeffrey Goodwin of the Snohomish County South Division District Court, and also Judge Joshua Grant from the Lincoln County District Court. The administrator of the courts, Callie Dietz, is also a member of the Ethics Advisory Committee. The most important function of the Ethics Advisory Committee is to give advice with respect to the application of the Code of Judicial Conduct to judicial officers in the state of Washington, and any judge may request an opinion from the Ethics Advisory Committee as to a judicial ethical issue, and we issue opinions to judges who request such opinions. You can submit an opinion request as a judge to the Ethics Advisory Committee. The address is on the Washington State Court's website. This is the, trying to remember the number of these fora that we have conducted over the years. We began in 1996 conducting Ethics Advisory Committee fora or forums, and have been doing those every 2 years since. I wanted to call your attention to the materials, which I hope you all have. They should be very helpful to you. We have the Code of Judicial Conduct itself provided for you in tab 1. Tab 2 are the applicable rules of professional conduct that would apply to persons who are not judges but are going to be or are judicial candidates. And this tab 2 sets forth the provisions of the RPCs that apply to attorneys who are seeking judicial office. Tab 3 is, I think, a very helpful handout. It's something we've compiled over the course of time called Frequently Asked Questions, and should answer a lot of questions that you may have about issues relating to judicial campaigns. Tab 4 is a compilation of various Ethics Advisory Committee opinions that have been issued over the course of time that have to do with judicial campaign issues, and we hope those will be helpful to you. At least they're collected in one place for you. And tab 4, or tab 5, I should say, are materials from the Public Disclosure Commission that relate to judicial campaigns, also collected here for your ease of reference. And finally, we have under tab 6, the State Secretary of State's 2014 campaign or candidate filing guide, which also collects some useful information for you. The Code of Judicial Conduct was revised in recent years, and a new code was passed in 2011 after a Code of Judicial Conduct task force had worked with the 2007 ABA Model Code of Judicial Conduct, and so we have a different look, if you will, to the Code of Judicial Conduct. It consists now of 4 canons as opposed to the old 7 canons, and Canon 4 is the part of the Code of Judicial Conduct that we'll be talking about most tonight, because that deals with judicial campaigns and related issues. So with that, I would like to introduce at this time, or reintroduce, Mr. Roger Wynne, who will spend about 10 minutes with you, giving you an overview of the new Code of Judicial Conduct, Canon 4. Mr. Wynne.
Thank you, Judge Hancock. Among the materials that you have, it's not bound in your book, it's a separate handout. It'd be easier for us to work from this, and I'll explain this to you in a minute, but you might want to have that out. I want to start by thanking all of you. As somebody who works within government, I know our system works best when good people stand up and say, I'll serve. So thank you for doing that. And my gratitude is enhanced by having you stick your hand up and say, not only will I serve, but I'm willing to go through a political campaign to do that. So to show our gratitude, what I'd like you all to do now is to go out and run those campaigns with one hand firmly behind your back. That's Canon 4. Now I'm going to offer you 2 bits of solace for that. One, with luck, everyone else, your opponents, will be playing by the same rules, so they will only have one hand as well. And 2, I think it's for good reason, because what lies behind all of this is that judges, although elected like other officials, are different. And we need especially to ensure that the public has a higher degree of confidence that judges are above political influence and above political pressure. So what we're going to do this evening is try to dig into Canon 4 and explore how it helps us strike that balance between both running a political campaign and keeping that public confidence. The handout that you have, it's a stripped down version of Canon 4, just the bits that are specifically related to judicial campaigns. There are other parts in there about political activities generally, or about seeking appointed office that we won't be getting into. Also in there, you will find the comments moved up closer to the rules that are discussed, that they're relevant to. But on the first page, let's turn to it now, is from the scope section of the Code of Judicial Conduct, just to give you a sense of the structure here, in case you haven't dealt with it. It is very much like any piece of legislation that you might have run into. 4 components in there. One are the rules, and those are the parts in the bold font there. The rules are the enforceable bits, the part that if you violate, you could find yourself in trouble. They're akin to the statutory text. You're also going to find the canons themselves, and as Judge Hancock said, there are only 4. These are the broad statements of principle that the rules then flesh out. The comments are in there. They serve 2 purposes. They interpret the rules, and they also set out some aspirational goals. And finally, like in any statute, you're going to find definitions, because of course, as lawyers, we can't just use words in their ordinary meaning, right? We have to have definitions. You find those at the end of the handout, at least the definitions that pop up. And you know when they pop up because you find a handy asterisk. Every time in every rule, the first instance of a defined term shows up, there's an asterisk. It takes some of the sport out of it, but still, it's a helpful guide. So go to the definitions whenever you see the asterisk. Also note 5 there in the scope. I think it's important because it tells us that what we're dealing with here are rules of reason. These rules don't trump statutes, they don't trump the Constitution. They're to be looked at in context. But again, remember the context here. The context is to keep the confidence of the public. So when in doubt, err on that side. Okay, so let's start walking through this document a little bit to get a sense of the full scope of what it covers, and I'm going to hand over to my colleagues here to talk about specific elements of it. I think Canon 4 can be reduced to 3 words. Money, that's what fuels your campaign. Speech, that's the guts of your campaign, that's getting the word out. And 3, proxies, people who can work on your behalf in the campaign. So let's explore those 3 words through the Canon 4. Let's talk about money. First, always follow the money, right? Look at Rule 4.1, subsection A, and then 7 and 8. We find 2 basic rules there. 1, you should not personally ask for or accept money. And particularly the asking for part, that can get a little bit dicey when we get into, campaign events where there are people there who are there to support you. And we'll have, Judge Erlick, I think, will be talking about that again later on. But the motivation here goes back to the background rule here. Want to avoid people thinking that judges are coercing them or making inappropriate use of their office to seek funds. The other rule is kind of a no-duh rule. It's don't use campaign money for your private benefit. There's statutes on that too, so that should be a no-duh, but there it is anyway. That's money. Let's talk about speech. Go to Rule 4.2 now, subsection B, 1 and 2. That's where it says what's okay. What's definitely okay is that you can speak on behalf of your own candidacy, no problem. Also okay, you may go out and seek, use endorsements from anybody, no problem. You're covered. Now let's talk about the limitations. And this is, we go back to 4.1. I never said these were well-organized rules. I'm jumping around. Rule 4.1, A, 10, and look at 10, 11, 12 in order here. First, again, perhaps no duh, but I guess not no duh for politicians generally. Don't lie. Don't lie and don't mislead, at least knowingly. Again, if you look at the comments a little bit here, we see that what we're getting at here is, again, a rule of reason, whether somebody reasonably could think that you were misleading them. So that's one rule. Don't lie or mislead. 2, avoid speaking about matters that are pending in court or impending in court, at least in a way that might affect their outcome. So pending is fairly straightforward. Again, these are defined terms. Impending, fancy word for basically saying it's likely to show up in court. But of course, if you are in court and you're a judge or you're an advocate, do your job. And that's carved out in here as well. So if you're in court, do your job. You're supposed to be influencing the outcome of the proceeding. But when you're out of court, essentially what we're being told here is avoid speaking about those matters when you're out of court. 3rd, make no pledge, promise, or commitment about matters that are likely to come before the court, at least if it would be inconsistent with the impartial performance of a judicial function later on. The comments help us identify what we're not talking about here. So maybe some safe territory. You may speak about your personal views about political, legal, or other issues. But the comments also caution that it would be best if you followed that up with, and I'll even quote here, acknowledging the overarching judicial obligation to apply and uphold the law without regard to your personal views. Get to the point where you can say that more loosely than I did, but that's what you want to be able to follow up on once you explain your own personal view that, hey, I also know that I have, if I'm elected, I have that obligation to apply the law fairly, regardless of what my personal view might be. 4th, and now we're going to jump to 4.2, and we're looking at subsection A, 1 and 3. 3 tells us you have to review and approve all campaign statements and materials that go out. Basically, you have to stay on top of that stuff. And finally, in general, you're supposed to act consistent with the, and these are defined terms, independence, integrity, and impartiality of the judiciary. Again, all with that rule of reason standing back behind it. So that's speech. Let's turn to the final word, proxies. Those who can help you out in the campaign. Family members may help you out. They may, unlike you, ask for and accept money. Committees, and you're going to be hearing a lot more about committees from my colleagues here. You may also set up committees to act on your behalf. That's addressed primarily in Rule 4.4. But beyond those exceptions, there are some other prohibitions that you need to keep in mind. And we're looking here, again, this is really scattered around. First, 4.1A9. And this perhaps is a no-duh rule, but do not use court staff, court facilities, or court resources. Allow me to say, duh. Don't do that. And take reasonable measures to ensure that no one does something on your behalf that violates the rules. And that's repeated, actually, in 4.1 subsection B, 4.2 A4. So basically, even though these others are independent from you, in terms of the public perception and public confidence, you ultimately are on the hook for what they do. So you need to be responsible for what they do. That's the general message. So again, thank you. Thank you for being willing to serve, for being willing to actually go through what it takes to serve. We're here to help. And now let me turn over to Judge Erlick. Or back to you, Judge.
I'll just introduce Judge Erlick again and note that Judge Erlick will have two segments here. Judge Erlick, as well as Judge Hogan, went through a contested judicial election, as I did but many years ago. And Judge Erlick and Judge Hogan will be speaking about various aspects of judicial campaigns. Judge Erlick's first segment will be concerning the financial aspects of running a campaign, and he'll also speak about reporting requirements and contribution limits. Judge Erlick.
Thank you. And Mr. Wynne pointed out on the part that's about cash. So I'm looking at my demographics here. I'm hoping most of you saw the movie The Graduate, 1967 movie. And Mr. McGuire approaches a newly graduated Benjamin Braddock, graduated from college, played by Dustin Hoffman. And Mr. McGuire goes up to young Benjamin and says, Benjamin, I want one word with you. And just one word? And, yes, sir. Benjamin, are you listening? Yes, sir. Class. I have one word for you. Treasurer. Is that short enough, Judge Hogan?
Perfect.
She was worried I was going to cut into her time. That's really all I have to say. The other, you all know the real estate adage, location, location, location. I will add to that in a political campaign, treasurer, treasurer, treasurer. What you want for your campaign in terms of money, in terms of reporting, is a good treasurer, preferably an experienced treasurer, and lastly, a treasurer that you can trust. Why is this? Well, as you're going to learn throughout this evening is the voters, our constituents, know very little about judges or judicial candidates. And the one thing that the press loves to report on is some type of misconduct involving reporting or otherwise involving money, and that will tank your campaign. It's quite easy to do if you don't have someone experienced. Things might be filed late, things might be filed inaccurately, and ultimately it ends up in your lap. It's happened with many candidates over the years, including judicial candidates, and that's why I'm putting my primary or initial focus on the fact of selecting a good treasurer for your campaign. As Judge Hancock pointed out, I'm going to be talking about two aspects. The first is the financial aspects of running a campaign, and the second is the reporting requirements and limitations on contributions and on spending. So, what are you going to spend money on? Well, the first requirement, and the only thing you're really required to spend money on, is your filing fee. Your filing fee will be 1% of the judicial salary. So if you are applying for Superior Court, it is 1% of $151,809, or $1,518 will be your filing fee. District Court will be 5% less. Court of Appeals will be 5% more, and Supreme Court will be 5% more than that. So that gives you a ballpark of what your money up front is going to be. So what else could you spend your money on? Well, there have been candidates on my court who basically spent no money. They put up a website, and this was even in a contested election, and they put up a website and they attended some forums. They attended the legislative district evenings where they do the endorsements, and that's it. And they spent $5,000 or less, and they've won. There were other candidates who spent, for my court, $100,000 or more and lost. So money won't dictate everything. Money is important, but just because you have a lot of money doesn't mean you're going to win, and just because you don't have a lot of money doesn't mean that you're not going to win or that you are going to lose. So as I stated, you could have $5,000, which would be setting up a website and maybe driving around the county, or $100,000, which means you're going to have written brochures and literature, mailings. You can do bus signs, you can do billboards, you can do yard signs. You can hire campaign consultants, you can hire campaign schedulers, you can even hire a campaign manager. You don't have to do it all. You do whatever is right for your campaign. You never know how much money is right until election night, and you'll think I didn't spend enough, or I spent too much, or I spent just the right amount. In my case, I felt, given that I won by 54% in the primary and a three-way race, I spent just the right amount. So I was pretty happy. It was close to $100,000. So what gets you elected? We really don't know. If we knew that, you probably wouldn't have all these campaign consultants coming out with varying ideas and recommendations. Endorsements are very, very important. From newspapers, from individuals, from public elected officials. I think those can be very important. I think that can be just as important as money. A good written statement, and I think my colleagues here will go over this, but a good written statement in the volunteers, the voters' pamphlet, I think will have great weight. And then if you list your public officials there who are endorsing you or various legislative districts, again, I think that will have great weight. That costs nothing. That just means you have a good writing skill, or somebody who has a good writing skill who can write up that statement. So in terms of getting money, money can mean many things. If you self-finance, that's fine. That might get you the money you need, but it might indicate that you don't have either support or reputation in the community that is going to broadly support a winning campaign. In other words, if you just put up $100,000, you don't really have much feedback on whether your campaign is getting legs or not. If you're getting $100,000 from the community, then obviously there's a lot of support out there that may be very broad among law firms, lawyers, or other members of the community. So this, again, can be somewhat telling on where you are in terms of the success of your campaign. I mentioned a treasurer. The treasurer's role is to manage and oversee the technical requirements of the PDC. That's really what you want. You want somebody who can keep the money, who can count the money, and who can report the money in an accurate fashion. Now, you can also have your finance chair. That's different than treasurer. And I'm telling you about these different hats of people. You can have one person do it all, or you can have, like I did, a finance chair, a treasurer, and an ask person. And those were three different people, and I'll get to ask person in just a moment. So your treasurer is just the details person. He or she is the person who's adding up the columns and submitting it to PDC. Somebody who is clearly left-brained. The campaign finance person, or your finance chair, is somebody who might be well-known in the community, who's going to head up your finance committee. And these are going to be your people who are going to go out into the community and try to solicit funds on your behalf. So that's your finance committee, and it's best if you can have well-known people in the community, but these are honorary titles of people who are going to go out and make the ask in the community. And then there's an ask person at an event you will be attending. This will be an event, it's not a fundraiser, let's be clear about this. It's an event you're going to attend with a lot of people supporting your campaign. The ask person will ask you to leave the room. You don't know what is going on when you leave the room. However, this ask person may be asking the people attending this event to make a contribution. You want someone who's a good speaker, who can get to the point, who's not long-winded, who's inspirational, and who can recap why you will make a great judge or why you are a great judge. That's your ask person. And I'll get a little bit more into why the rules require that you leave the room. It's a fiction that goes on, but I'll explain that more in just a moment. As Roger pointed out, we can't solicit money except from your fortunate family members and people on your campaign committee. So in theory, you could ask 1,000 people to sit on your campaign committee and then ask them for money. But those are the exceptions from your family members and from your campaign committee. You may solicit contributions. Just FYI, there is 4.1 is based on the ABA model code. I want you to be aware about developing case law out there. There's a case that came out in 2002 called Republican Party versus White. It was a Minnesota case, federal Minnesota case, went up to the 8th Circuit and ultimately up to the U.S. Supreme Court. The U.S. Supreme Court said that Minnesota's version of its judicial code was unconstitutional because it prohibited judges from announcing their views on political or controversial issues that might come before the court. The U.S. Supreme Court, in a 5-4 decision, said that it was violative of judges and judicial candidates' First Amendment. So why am I talking about it? I'm talking about it because on remand, when it went back to the district court and wound its way back up, the case got bigger and it now included solicitation and partisan affiliation. The 8th Circuit held that it was unconstitutional to prohibit judges and judicial candidates from soliciting funds from third parties or from affiliating with partisan organizations. This is just an 8th Circuit case. It's not controlling, obviously, the 9th Circuit. There's nothing dispositive of the 9th Circuit. Ultimately, this will end up in the Supreme Court. It's a different court than it was when Sandra Day O'Connor, who wrote her concurring opinion, Republican Party versus White. So right now, 4.1 is good law. It's enforceable. You cannot solicit. However, you can accept a contribution which is just given to you. And the procedure is someone gives you an envelope at an event or says, I want you to have this. You may say thank you as soon as possible, get it to your campaign treasurer. So that is allowed. You may accept money which is, or contribution which is given to you. And I'll just read to you from the ethics advisor opinion. When an unsolicited contribution is delivered directly to the candidate, receipt and prompt delivery of the contribution to the appropriate campaign official is not prohibited. The appropriate campaign official is typically the treasurer. Okay, so there's going to be an event, and again, not a fundraiser. How does it work? Well, first of all, it can't be billed as a fundraiser. It's an event in support of Judge so-and-so or candidate so-and-so. You cannot have, if you don't show up, the candidate, all these prohibitions don't apply. But if you intend on being at this event, you cannot charge the event. You have to have somebody else make the ask. You cannot be in the room when the ask is made. You have to ask, you have to tell the ask person what the limits are, because people may want to know what the limits are. And so the person asking can say, you know, you can contribute in the aggregate per election $1,900 per person. And so that person has to know what the limit is so they can pass on the information to those who are attending. The asked person should work with your treasurer so that money can go from the asked person who might be collecting it, or say, just give it to so-and-so who is the treasurer. The rules are, if it's less than $25, it does not have to be reported individually, just you accumulate those amounts. If it's between $25 and $100, you need the name and address of the contributor. If it's over $100, then you have to have the employment information of the contributor. So I think as a blanket rule, get all the information, even if it's $25. And the reason for that is this money aggregates. So you don't want to have to necessarily have your treasurer or your campaign or your finance people saying, oh, well, they gave $25 once, and now they're giving $50, and which will apply. Just get all the information, including the employment information, because it just makes a lot more work for your campaign to go out and have to call these people and say, where is it where you work, and hunt them down and all that. So get all this information up front. There will be lots of forms. I'm not going to go over all the forms or what they are, except there's a lot of them that need to be filed. There's C1s, F1s, C3s, C4s, and L. Everyone has to file C1 and F1, even if you are doing what's called mini reporting, which I'll get to in just a moment. There's a great website on the PDC. This will give you basically everything you need to know. Nan has provided it in the materials that's been given to you tonight. Go on the website. I'll give you a really quick overview. C1s, everyone has to file. It's basically lists your candidacy information, your basic information on your candidacy, who's your treasurer, and what the address is of the campaign. F1, everyone must file. That's your financial affairs statement. You have to list every asset and every liability that you have, and the value as coded. And then there is periodic reporting under C3 and C4. The L form is for the loans that you receive from third parties or that you have made to the campaign. So, big overview. Washington State, in a national study done probably about a dozen years ago now, I don't think there's been an update since then, was ranked number 3 in terms of public disclosure rules. So we have really strong transparency in this state for public disclosure. As Mr. Wynne pointed out, there is the requirement under the PDC rules that you review all of the financial forms and that you sign off on them. There is I'm not going to call it, there is a potential conflict with the conduct rules on recusal. In other words, the problem is if you know who made contributions, do you have to disclose that? And do you have to recuse? And Rule 2.11 basically gives you a little bit of a formula on the factors you can consider. Justice Charlie Wiggins tried to get an actual formula that was quantitative, and now what we're left with is something that is only qualitative. You have to decide how you want to handle this. You're required to sign off on the contributions that are made. It's going to list every contributor and the amount. And some judges look at it, or judicial candidates look at it, sign off. Other judges do what I do. I ask my treasurer to cover up the names. And then I just looked at the amounts and I certified it, that I had checked the amount and that they were accurate. I had a colleague who wrote a cover letter to the PDC and said that I am relying on my treasurer, I am declining to look individually at these names. So however you want to do it, I just did not want to know who my contributors were or how much they contributed. I mean, I had a good idea who was contributing because they were showing up at the events, but maybe they didn't give money. Maybe they gave $10, you know, in which case, you know, so I didn't want to know who they were or the amounts that they contributed, and that's the way I handled it. I covered it up. So Rule 2.11 says that a judge may disqualify himself or herself if you learn by a timely motion by a party that an adverse party has provided financial support to any of the judge's judicial election campaigns within the last 6 years in an amount that causes the judge to conclude that his or her impartiality might reasonably be questioned. And you should consider the total amount of financial support versus the amount that this contributor made, the timing between the financial support, the pendency of the matter, and any other circumstances pertaining to disqualification. This is based essentially on the, partly on the ABA model rule. I don't think it's a workable rule, and I'll tell you a big problem I have with it, which I'm pretty certain that 90% of my contributors were lawyers. And the rule does not address lawyers. The rule addresses parties. And what are the chances that the parties who show up in my courtroom contributed to my campaign? Probably not. Probably, you know, nil. I mean, they don't know, they're not in courtrooms regularly. Most of the parties that I see in my courtroom are there on a one-time shot, unless they're an insured who is represented by an insurance company. Now, is an insurance company a party? Not really. They're not a party in Washington. And so the insurance company gave me a lot of money. I don't think there were any that were, but did. But if there were, then does this rule even apply? If one of their insureds is in my courtroom as a defendant, I don't know. It's not, it doesn't state that. The other problem I have is one of the biggest issues we've had with campaign contributions has been indirect contributions, basically the PACs, and they don't show up in the courtroom. By way of example, the BIAW contributed a lot of money against a sitting Supreme Court justice. And the BIAW, much like insurance company, is typically not the party. They may have a constituent who's a member of the BIAW. So this is what the rule is. I don't think it does a very good job in telling us when we have to recuse because there's been a financial contribution. Okay. Campaign committees, you can, Rule 4.4 says that you can set up a committee, and one of the roles of the committee is to ensure that the campaign committee complies with all applicable statutory requirements for disclosure and for divestiture of campaign contributions. Limits. Let's see. So there's something called mini reporting. That means you don't have to do you have to do a C1, but you don't have to do the C3 and the C4, which is the periodic reporting, if you are going to receive no more than $5,000, if you're going to receive and spend no more than $5,000 from campaign contributions, and no more of that is $500 individual. There is the exception being self-financing. You can self-finance without any limit. If you want to put $100,000 into your campaign, you can do that. The limit for judicial candidates is now $1,900 per person per election cycle. So assuming you're going to have a primary and a general, it'd be $1,900 per person, $3,800 per couple for each of those elections. Okay, $1,900 plus $1,900 for the primary, $1,900 plus $1,900 for the general. You can loan yourself, you can loan your campaign as much money as you want, but you can only receive back $5,500 from the campaign. So if you loan your campaign $20,000 and then you collect a lot of money from other contributors, then you can only pay yourself back $5,500 of the $20,000 that you loaned to the campaign. So I will answer questions after my fellow presenters have concluded their presentations.
Thank you very much.
Thank you.
Now I'd like to introduce my distinguished colleague, Judge Vicki Hogan, who will speak on putting the committee together and endorsements. Judge Hogan.
Thank you. So I want to know the audience, how many of you are ready to file on May 12th for a position? Come on, I know some hands. Of those that have their hands up, how many are sitting judges now other than Judge you and Judge Strickland? Okay. Okay, great. I'd just like to know who I'm talking to, because generally it's non-judicial officers that come to this. They haven't been in a campaign, they don't know what they're doing, and so it's nice to know who you all are for us, because then we have an idea of who we're talking to. So of all the people that are here, how many have ever worked on a campaign other than their own judicial campaign? Okay, so just a few of you. I was thinking back as Mr. Wynne started talking, I worked on my first judicial campaign in 1984 and realized that was 30 years ago. So, you know, it's a process that if you haven't done it, it's good experience to be in someone else's campaign rather than your own. The campaign committee, there are 3 ways to do a campaign committee. Putting it together, your steering committee. This is a group of your very best friends who, when you meet every week, will sit down with you and tell you, oh my gosh, Judge Hogan, you're running against someone who's got these qualifications. Where are you strong and where are you weak by comparison? And they will do a self-assessment of your strengths and your weaknesses, and they will give you good advice to put together your campaign strategy. And so they should be honest people, people you trust with your firstborn, and they should be then the people that Judge Erlick talked about, and those are your workers, whether they're in charge of your calendar, whether they're in charge of raising money, whether they're in charge of figuring out your media. What are you going to do? What does your campaign look like? It doesn't matter how much you have to spend, you have to figure out how much you're going to spend in what areas. If you're going to do a direct mailing in Pierce County and all you have is $25,000, that's all you'll do, is one direct mailing and pay your filing fee. That's how expensive it is. Statewide, oh my gosh, Judge Tricky, Judge you, I don't know. I can't even imagine. So your county dictates what you're doing, your locality dictates what you're doing, and the state dictates what you're doing, what your audience is. Your campaign steering committee will help you put together your plan. What is your plan? Are you going to do mailings? Are you going to do bus signs? Are you going to do billboards? Are you going to do newspapers? Are you going to do yard signs? Are you going to have solicitation letters, or are you going to do it with the website and the internet? Each of these events costs money, let alone putting on a kickoff or get together to meet and greet in a public forum with food and all of that entails. Your campaign committee will help you do all of that. So that's one way of doing it. The other way of doing it, at least in Pierce County, I'm sure in King County, I don't know who the names are, there are consultants, professional consultants that you pay money to who will handle these aspects for you. But they may not sit down with you and develop your public relations statement, your campaign brochure, write your speech for a kickoff or a meet and greet or that type of thing. And they may not put together the profile of what is the candidate going to be in representing the office that you seek. And so the combination is the third way of doing it, with a consultant who handles all sorts of things, but you have a steering committee that will help you define your campaign and what it is you're going to do. Because if there's one piece of advice on the money side, it's money, money, money. My piece of advice on your campaign is make your plan and don't change it. Because the first time you talk to somebody you know, they're going to say, oh my gosh, I really think you should be doing, or did you see they're doing yard signs, and you've eliminated that from your budget. all you end up doing is adding more gray hair and worrying about, I don't have 20,000 for yard signs to cover the state, or 50,000 for yard signs to cover the state, and you're worried about you're always behind, and then you're killing yourself because you're not doing what you plan to do. You think you should be doing something else. You're comparing your program to someone else's. My piece of advice is listen to your steering committee. They will define who and what you are based upon what your personality is and the message you're sending, and stick to it. Thank people for their advice, tell them you'll consider it, and move on. Once you start second guessing what you're doing, it's downhill from there. I've seen campaigns fall apart before the primary because they're worried about, I'm not doing X, Y, or Z. The steering committee, nothing I have to say are in the canons. This is all to-dos. There isn't any material I can give you except 30 years of experience. Your steering committee chair should be the biggest name you can get that will reach the community you're trying to reach. And my personal opinion is it isn't a lawyer necessarily. I believe a bigger campaign is your grassroots that reaches out into the community. It isn't just a lawyer. But you want a name of your chair of your steering committee or your campaign to be someone that would reach a broad base. I would love to run for a state office and have former Governor Christine Gregoire be my campaign chair. I mean, that name is known all over the state. Would she do it? I don't even know the woman. But you want a name that in your community would be someone that people would recognize. Because your list of endorsements that I'm going to talk about now is no one is going to know you. Your friends are going to know you, the people that you reach in community events, meet and greets, and forums, but they're never going to know you as a candidate. And so they're going to look at your list of endorsements, however you broadcast that on the media, in the newspaper, with mailings, and they're going to go, oh wow, Christine Gregoire supports Vicki Hogan. I loved Governor Gregoire. I'm voting for Judge Hogan. You know, that's kind of how endorsements work in the real world, I would say. But you want a name that's going to reach into the community that will give your campaign credence and value, and that is respected, and that people will know. But you have to be careful on the endorsement side, and I'll just switch over to that you don't want to get too aligned with the political party because we are nonpartisan. And so you can't have a big D or a big R as chair of your committee necessarily. It ties you to a party that you don't want to be tied to. The aspect of seeking endorsements, I believe there are three aspects to endorsements. First of all, everybody that you know should be endorsing you if they like you. And you should have your steering committee and your worker bees out signing endorsement cards and getting endorsements for you so that you can broadcast these endorsements. You get endorsements at the kickoff, you get endorsements at meet and greets, and these are people who not only donate, but then will do work for you. If you don't have a campaign consultant that has a set of worker bees to stuff envelopes for mailings, then those are the people that do all that work for you. Putting up 500 yard signs in the county is a ton of yard signs, and it's a ton of hard work. And you need people that know how to do it and go out and put them up. And so your endorsements come from your friends, your colleagues, your associates, the community-based organizations. All of those people can endorse you. The other set of endorsements that you have to have, you've got to have both sides of the aisle. You've got to have Republicans, you've got to have Democrats. And getting those endorsements is either through your very impressive campaign chair or co-chair connections, or through a consultant who can go out and make those contacts in the districts. I want to say in 2012, In Pierce County, I don't know about King, I think I probably went to 6 legislative districts, which aren't all the districts in the county, but you go to the key districts, the Ds and the Rs, and you know, it's all you do is just go out to these places and sell yourself in 2 minutes and hope you get their endorsement and hand out your literature, and then they vote, and you try to get the endorsements of the 26th district, or the, doesn't matter where you are, 31st district, or the 2nd district. Wherever your voter base is, you need those legislative endorsements from the Democrats and from the Republicans. And the third type of endorsements are the organizational endorsements, not the political endorsements, but you're looking at your Washington State Bar. They rate or rank judicial officers, Washington Women Lawyers, the Minority Bar, the Lauren B. Miller Bar. There are tons of organizations that rate and rank judicial officers as exceptional, well-qualified, you know, not qualified. And those have an impact in your literature when they go out in mailings or out when you hand them out at meet and greets for showing the community how you are supported by various organizations that have in-depth interview and application processes for you to go through. If you've ever sought a judicial appointment, you filled out the governor's 85 million page questionnaire. And what have you done for the last 10 years or the last 15 significant cases you've had or judicial decisions you've rendered? And every application for every legislative district and for every organization is different. Wouldn't you say, Judge Erlick, they're all rarely...
They all have their own agenda.
Yeah, and so they want to... So you think you fill out one and then you can just copy it and change the name, and you can't. And so having a steering committee or someone that's good at writing can help you do those applications or get to those, make those connections, and help you write a good piece for the voter pamphlet, whether it's the state or your county has a voter pamphlet. But your steering committee and your list of endorsements and your campaign statement really come out of your steering committee and your endorsements and how you have developed your plan for your campaign. I think we all have a different organizational plan. I learned when my first campaign was for an open seat in 1992, all my opponent did was look at my public disclosure filings for the prior month, and then he did everything I had done the next month. He didn't have a plan at all, and all he did was follow my plan, and he hated campaigning. So if you like, I concur with Mr. Wynne, it's a wonderful thing that you're all here and willing to do this, but you really should be out there having fun while you're campaigning. It isn't fun some days, and other days you wonder why you're doing it. But generally, if you're not having a good time, then something's wrong with your plan or how you're set up, or you have treasurer worries, or you have disclosure worries, or you violated something and you have in your heart, but you just don't know how to get out of it. But I too would welcome questions that you have about the do's and don'ts of setting up your committee and endorsements, but I think that uses up pretty much my time.
Thank you very much, Judge Hogan. And now on to Mr. Doug Ende for attorney compliance with requirements under the rules of professional conduct and the Code of Judicial Conduct and the interplay between the two. Mr. Ende.
Thank you, Judge Hancock. I'm the closer today, and my plan is to throw a few fastballs and get back into the dugout as quickly as possible. And serendipitously, I have a very simple message for you today. If you'll turn to tab 2, you'll note my materials consist of 2 pages and 2 rules. The fundamental message is this: there is a difference when it comes to judicial election between lawyer candidates for judicial positions and judge candidates for judicial positions. It's not so much a substantive difference in the obligations. It's a curious procedural difference, and I'll talk about both of those. And just for the sake of curiosity, I'll ask the inverse of Judge Hogan's question. How many of you are lawyers planning to file for a judicial position? A few, so I'll keep talking. The judges in the room can now check their email or play Candy Crush. Although I guarantee you'll find this interesting if you care to pay attention. Let's talk about the substantive difference between the ethical rules applicable to lawyer candidates and judge candidates. If you look at Rule 8.2, which is on page 61, and particularly paragraph B, here's everything you need to know about the rules applicable to lawyer candidates. A lawyer who is a candidate for judicial office shall comply with applicable provisions of the Code of Judicial Conduct. In other words, turn back to tab 1 and read the Code of Judicial Conduct. Very simple idea. And because the Code of Judicial Conduct technically applies to judges and judicial officers and not to lawyers who are candidates for judicial office, for those rules to apply to lawyers, we need this provision of the Rules of Professional Conduct to clarify that there are enforceable ethical rules applicable to those individuals. The rules themselves, the same rules. And in fact, I didn't include this provision in the materials because it's duplicative, but Rule 8.48, M of the Rules of Professional Conduct say it's professional misconduct for a lawyer to violate the Code of Judicial Conduct. So we say it in two different ways. Now, here's the interesting piece. Why is it this way, and how does it work procedurally? If you'll turn to page 62, Rule 8.5, paragraph C, the Rules of Professional Conduct actually carve out from the authority of the Rules of Professional Conduct judicial conduct. So in other words, and I'm oversimplifying a bit, these rules of professional conduct and the procedural rules for enforcement of lawyer conduct do not apply to judges performing acts in their judicial capacity or as candidates for judicial office. That jurisdiction is reserved for the Commission on Judicial Conduct. And the way I like to think about this, and really this is the last thing I'll have to say to you today, is think about conceptually there being 4 quadrants, 4 possibilities in a judicial election. Quadrant 1 is you're a judge, and you run for judicial office, and you're elected. At all times, you are clearly subject to the jurisdictional authority of the Commission on Judicial Conduct, not the Rules of Professional Conduct, not the Bar Association. Quadrant 2, you're a judge. You're running for judicial office, and you do not succeed in gaining that judicial office. Now you're a former judge. As a matter of practice, the Commission on Judicial Conduct are still going to look at the conduct of that individual as a judge and will exercise continuing jurisdiction, if you will, over the former judge. So that's what the Commission on Judicial Conduct. Quadrant 3, you're a lawyer and you're a candidate for judicial office and you win. Well, now you're a judge, and the Commission on Judicial Conduct is going to take up any allegations of unethical conduct during the course of that judicial campaign. And finally, there's quadrant 4. You're a lawyer, you're a candidate for judicial office, and you do not prevail. You were not a judge, you did not become a judge. That quadrant is reserved for the jurisdiction of the Washington State Bar Association. So in the unfortunate event that there are allegations of ethical misconduct, those will go to the Washington State Bar Association Office of Disciplinary Counsel for review under the Rules of Professional Conduct. Thank you.
Mr. Ende has closed it out, and I wish the Mariners would do the same in recent games. So, We would like to open it up at this time to questions and answers. I hope you have questions for us, and we would be happy to entertain questions at this time.
I have a few, and one of it is probably more of just a change in society as we are today. When the judge spoke of, or one of you spoke about, be careful with money and receiving money. Also remember, we are a society now with phones, cameras, and everybody's looking. My thing is, I hand you $1,000 because I came to you as the candidate. I hand you $1,000 and your rule says, get it to your campaign person.
ASAP.
That's right. I advise you. And I've watched candidates go down, even though I'm from Texas. I advise you, with cameras going because people are snapping or whatever, if he hands you $1,000, hand him one of those forms with, and have him fill it out. You have to make time for it at that moment. Because, make sure you have all the information there, because I've watched some very good candidates lose their position. They shouldn't have lost because somebody handed them money, and at that spot, and that camera caught it, just at that spot, their opponents took their position away from them. So if you can have within your limits or within your reach, some kind of form with you to fill out and hand it back to that person, then take it to your campaign manager, it only protects you.
It's a very good point, and I think the optimum situation is not to receive contributions yourself as a judicial candidate. Very good point. Just don't put yourself in that position.
Right.
And have your treasurer or an assistant treasurer, someone available to take contributions and direct them to that person as opposed to taking it yourself. Good point.
One other thing, and this is very confusing. As you were saying, it's not clear on how you recuse yourself or recusal. Okay, you're out campaigning and you're going to events, you're shaking hands, you meet and greet, you may be knocking on doors to get yourself familiar with. And these cases wind up before you in a court of law. Oh, I didn't look at my contribution list, but I was here shaking hands with these people out here doing this event, this event, this event. And where, is there a conflict there somewhere or something to address that could probably come as a possible problem if those people or whatever shows up before you?
Well, it's an interesting point, and I might digress for just a moment. The Code of Judicial Conduct Task Force had actually recommended a rule concerning campaign contributions and recusal, which would have had a set number, basically 10 times the maximum contribution limit, which would give rise to the need for recusal. That was not accepted by the state Supreme Court, and the code now provides for, interestingly enough, a subjective standard on the part of the judge to determine whether campaign contributions should cause that judge to recuse himself or herself. It says, a judge may disqualify himself or herself if the judge learns by means of a timely motion by a party that an adverse party has provided financial support for any of the judge's judicial election campaigns within the last 6 years in an amount that causes the judge to conclude that his or her impartiality might reasonably be questioned. So it's a subjective standard, and I think the only subjective standard we actually have in the code at this time, as opposed to a reasonable person standard that might apply to other provisions of the code. So this is maybe the first effort on the part of the court to address the issue of campaign contributions, and I would say it might be a first step in the process.
Alan, if I could, there's an irony or a paradox about this, because the way the rule is set up is that the provision actually gives a recusal determination upon the motion of an adverse party. So what that means is, if you did what I did, which is you didn't know who your contributors were, or in the case of many of us who've been on the bench for a long time, we can't remember, all of a sudden, somebody appears in my courtroom and said, well, Judge, and this is usually a 6-year rule because that's what it's looking at, but Judge, 6 years ago, this party, which again is highly unlikely that a party would have given me money, but this party contributed to your campaign, and we're going to ask you to recuse. Well, before the attorney for that party brought it to my attention, there's a pretty good chance I never would have known. So now I'm placed in a position of, oh, well, now that I know, what would I do? But again, you know, these amounts are, from my perspective, fairly de minimis. If a party gave money, I mean, the max it's likely to be is $3,800. And I guess is a question of if it would ever rise to the level of making a judge impartial. So I don't think it would come up often.
I think too, a casual acquaintance or a casual meeting of someone in the community isn't going to necessarily raise an appearance of impropriety that would necessarily require a judge to recuse. I can think on any given day we can see 40 or 50 people in our courtrooms, depending on the dockets we have, and to recall someone that you might have met doorbelling or at a function, slim to probably almost impossible to remember everyone you meet. They may remember the judicial officer, the candidate, but individually you may not recognize or remember someone that you meet. And if they said, oh gosh, I met you when you doorbelled at my house, then you can put it on the record and see if the other side has a problem and disclose and then recuse. But I don't know that would rise to the financial contribution is much more significant than an inadvertent meeting of someone in the community while you're campaigning.
I pointed that out simply because, once again, we're in the age of webcams, videos, and what you call bites and sound bites. And you're out campaigning, you really don't know what half the people you're speaking to. And you might be at this function, this function, this function, this function, and people are following you around and shaking your hand. And then getting a video and putting it out there, and the adverse party put it out there. Now these people are showing up before your court, and somebody is saying, and that's what I was saying, is there some way that with the technology, do you get yourself protected when you're out there campaigning and that kind of thing happens to you? Or it's just best that if that shows up, just recuse yourself and go on about your way?
I would just say if someone would have to call it to my attention, and if I had a meeting with somebody or met somebody, it happens all the time. We get a room full of jurors, of prospective jurors, and one of the questions we always ask is, do you know anybody in the courtroom? Do you know the attorneys? Do you know the lower bench? Do you know the judge? And a lot of times I'll have somebody in the back say they know me, and I don't have a clue who they are. But they've seen me speak somewhere, or they saw my name in the paper on some case or something like that. So, let's say, well, I know you. Well, how do you know me? We met years ago at a party or at some function or something like that. Is there anything about your knowing me which is going to influence you from sitting as a juror in this case? Oh, no, it's not. It would be the same situation. So if someone said, well, Judge, we know that you're friends with this person, or you met this person at one time, I'll say, quite honestly, it was so long ago, I meet a lot of people. The fact is, all of us, as we who are judges, meet hundreds, if not thousands, of attorneys at social events and bar activities every year. We can't recuse on every case because we shook an attorney's hand or had a conversation with them. There's a lot of soul searching that goes on as to when you want to recuse. And what judges can do best is simply disclose and say, I met this person, or I used to work in a law firm with his sister or something like that, and see if anybody has a problem and have that discussion. But the fact of the matter is we are not going to remember literally the hundreds and thousands of people that we meet on the campaign trail, at the Puyallup Fair, these legislative districts, church meetings, Rotary clubs. It would be an impossibility.
We had a question back here.
Yes, thank you. I have two questions. One is, do endorsements from persons, just citizens, do they have to be in writing? And if they do, is that writing satisfied via email or some other kind of electronic exchange?
To the best of my knowledge, there is no requirement that there be a written document that sets forth an endorsement. If you have it, you have an email or even a verbal endorsement that you can rely on, that somebody you know and has endorsed you, I think that is satisfactory. There's nothing in the code that requires a written endorsement. Other comments from others?
I always say get it in writing.
It's a good idea.
I won't use anyone's name, especially if there's two Roger B. Smiths, you know, you wanna make sure that it's Roger B. Smith, not Roger D. Smith, and I think you're always safer to have it in writing, even if it's just on a piece of paper or cocktail napkin when you're out to dinner at a restaurant and someone says, here, you can use my name. It's always better to have it in writing.
That's right. Did you have another question? Did that answer both of your questions? Okay. Others? Yes, ma'am.
What about a pro tem being photographed in a robe for their campaign literature?
Anybody like to address that?
Sure.
I know that question had come up in preparation for the forum. Judge Erlick.
Well, it is not entirely, there's nothing directly on point in Washington. We have an opinion, let's see, 88, 13, 88.3. 88.3. And Ethics Advisory Opinion 88.3, the question was whether a district court judge could wear a robe when he was running for Superior Court. And the Ethics Advisory Committee said that was fine so long as it wasn't misleading, i.e. it was very clear that he was not an incumbent Superior Court judge, that he was a district court judge running for Superior Court. As a district court judge, he could wear the robe. There is a split of authority in other jurisdictions as to whether pro tems or part-time judges, and they're two different things, can wear robes or not. The majority say no. There was a PDC opinion that came out that said that it was a judicial candidate, Kevin McCann, who was running for office, and, oh, is it in there? Yeah. Okay. And it's,
There's a link to it if you go to tab 3, page 70. There's a link to there's a citation.
and the question was whether or not somebody who had been a pro tem judge could wear the robe. And the PDC looked at RCW 4217, which has to do with libel and defamation, looked at a PDC opinion, and looked at the Ethics Advisory Committee opinion that I just referenced, 88.3, and concluded that so long as it was clear that Mr. McCann had served as a pro tem judge, and only a pro tem judge, that he could wear that robe. One of the other complaints was that it looked like it was in a courtroom, and the complainant said that it was use of public property. Actually, it was a mock courtroom that Mr. McCann showed up in. So the PDC is not really controlling over either the Conduct Commission or the Bar Association Disciplinary Council, but I think it might provide somewhat of a safe harbor because they said it would not violate PDC rules.
It's an interesting question because though this question arises in the real world where a candidate for judicial office would post a picture of himself or herself, part-time judge, pro tem judge, these are terms that are not they're not going to be defined in the campaign literature and the photograph. The code actually defines and distinguishes between part-time judge and pro tem judge. A pro tem judge is someone who serves only periodically on a sporadic basis, while a part-time judge is one who serves on a regular or periodic basis in excess of 11 cases or 11 dockets annually. So a part-time judge does more judicial work than a pro tem judge. These are terms of art that wouldn't necessarily come into play with regard to this matter of a photograph of a person in a robe, but it might provide some guidance. And the key is full disclosure and making sure that this is not misleading. I would hope that candidates for judicial office who've only served maybe once or twice as a pro tem judge would not have their picture out there in a robe saying pro tem judge. That does not seem appropriate to me and inconsistent with the code. Any other thoughts on that? Other questions? Yes.
How quickly are the opinions delivered?
The Ethics Advisory
Yes.
Committee opinions? Depends on the complexity of the issue. The committee also pays attention to time constraints. If there's something that needs to come out quickly, we convene quickly and get something out as quickly as we can and try to meet a time deadline. On other occasions, it might not be something that's pressing, and so we can spend a little more time thinking about it. We do most of our work by email, exchanging emails and thoughts about the question and have a proposed opinion, and we'll discuss that, make amendments to it. So it depends on the circumstances. I hope that answers your question.
It does.
Let me just follow up on that if I may. First of all, ethics advisory opinions are only available to judges and judicial officers. And there in King County, there is an organization, a committee of the Bar Association, King County Bar Association, called the Fair Campaign Practices Committee. And if you think that a judicial candidate is violating the code, either RPCs or the Code of Judicial Conduct, you can make a complaint. Best practice is to have somebody make a complaint on your behalf. In other words, the candidate doesn't complain, but someone on the candidate's behalf complains that the opponent is violating the rules. They'll do a very quick turnaround. They are very time sensitive, and that committee is available to any candidate, whether you're an incumbent judge or just a candidate.
And any complaint to the public disclosure, you'll never see a response until way past the general election. They're not responsive at all.
Aaron?
Yes,
Yeah.
any questions?
Are there things that you judges and Mr. Ende, that although they may be permissible apparently by the rules, you yourselves wouldn't engage in the act or would hope that your opponents would not, that come up commonly?
One thing that comes up commonly is questionnaires, and you get them from every organization out there, and they want to know what your position is on gun control, on abortion, which just doesn't come up in Superior Court, and certainly it's not coming up in District Court. And they can be very time consuming. It's generally you can't answer 90% of the questions. And so I generally didn't answer any of them. I came out with like 2 paragraphs that just said, thank you for your questionnaire. As a judicial candidate, I am subject to the Canon, the Code of Judicial Conduct. I listen to every case based upon the facts, and therefore would not be able to give you very valuable guidance on the questions that you presented in your questionnaire. So as a general rule, I mean, I'm not talking about the minority bar associations or the other bar associations, but we got some from out of state. I mean, they came in from all over, and I just generally didn't fill them out. I didn't think that they were very helpful to the community. In fact, I thought that they were misleading. And if I could just sort of follow up on that thought, and you're going to get, it's very confusing to the public, the fact we vote for judges. We are the only candidates who do not take a position on issues. You know, the governor takes a position on death penalty. Your state legislator has a position on transportation. You know, and so when people have an intellectual challenge in understanding that we don't have positions on anything. And so there's a cognitive dissonance going on. Well, if you're not taking a position, why are we voting for you? Which is a very good question. But it's in our Constitution. So it can really be a teaching moment. And I had a little stump speech, which I don't remember anymore, but it went something to the line of, I'm very glad you asked that question, death penalty. It is the law in this state, and I would be duty-bound to apply it as a judge. It's probably not a very good example. What's your position? Are you going to be a law and order judge? Or what's your position on drunk drivers? I don't have a position on drunk drivers. And the reason is I have to decide every case based upon the facts presented to me. And then I personalize it. And I said, I don't know what your position on drunk drivers is. But for example, if you felt that all drunk drivers should be locked up, you might want that drunk driver to have a fair chance in court if that were your son. And you can sort of get well, of course I want my son to have a fair shot in court. So if you can explain what the role of a judge is, that's really valuable to the public, because then they understand why you're not talking about these issues. Because you're going to be looking like you're ducking talking about an issue unless you explain why you cannot talk about the issue. And it can't just be, well, the code doesn't allow me to talk about an issue. It has to be, here's the reason for that provision.
I think all of us too have different bars of what we will individually do. I mean, even if we ask the three of us who sit on ethics advisory committees and conduct commission, I am still stunned, to have one of my colleagues say, well, hey, let's all go down to the Republican whatever. Well, first of all, it's not election year. Two, we can't go to partisan events. I mean, you don't realize what you give up as a judicial candidate, let alone as a judge in that regard. And so there's so many opportunities to answer that question with examples that we're faced every day. And what will we do in this situation? What will we do in that situation? It's almost astounding on any given day that it really was, let's go support the county executive. Oh, no, we can't do that. It's not a judicial officer. And it's not a campaign year. And so there's so many tiers of levels that you have to consider in what will we do or what won't we do for every situation. I think it's shocking to new judges to realize now what they're tied to, and for candidates who are not judges, who haven't really thought about these various conflicts, what they're going to be faced with. And now they're bound by the same code as we are. And it's very frustrating to have a non-judge running, and they don't seem to care a whit about the Code of Judicial Conduct at all. And the rules of professional conduct, they don't even remember that they're in their state rules. And there isn't a lot of remedy for a candidate, a judge who's been challenged with the Public Disclosure Commission, with the Bar Association, with the Code of Judicial Conduct. So you just have to, with your steering committee, decide what kind of a campaign are you going to run within the rules that you are going to follow. And I think each judge makes that decision themselves for every situation that's presented. There's so many examples.
Judge, you, a question?
Yeah, so it's more of a comment in sort of, because the questionnaires are so different. I have to admit, I had really seen one in 14 years with John, and now I'm doing them. But there are now different questionnaires for judicial candidates and others, so make sure you're filling out the right one. And they really have been tailored much better now to really address judges in terms of access to justice and rules, and so they're much better. But I would encourage people to fill those out and be thoughtful and make sure you're filling out the right one. But they're different.
Yeah. Bar Association questionnaires as opposed to
No, labor,
political
legislative
action
districts.
committees or things like that, or others for that matter. Yes.
And Judge Yu's point is very well taken. I mean, there will be organizations that you will want their endorsement, in which case you may choose to fill in their questionnaires. So, but you're going to get a slew of these, and I did fill in some questionnaires, but it was an organization that I specifically would want the support of, that was well recognized, and not a single issue, typically not a single issue organization. Thank you.
And even the legislative and applications for endorsement or questionnaires are all different. The Democrats are looking at something completely different than the Republicans, and you have to make sure you're filling out the right one and focusing on remembering what their agendas are as well.
So for clarification, there is a carve-out grace period when you're a judicial candidate for attending partisan events. We cannot do it as incumbent judges unless we're running for re-election. So judicial candidates and judges running for re-election or for a higher office can attend partisan events. So you can go to the Democratic districts, the Republican districts, the Republican, whatever it is at the Puyallup Fair that they have every year. That is allowed while you are a candidate. You cannot identify as a partisan. So you can't go up and say, well, I'm a good Republican, therefore you should support me, or I'm a good Democrat, therefore you should support me. But you may attend those events for purposes of promoting your candidacy. In addition, you cannot endorse non-judicial candidates. So you cannot endorse county executives, mayors, anybody but other judges or judicial candidates.
Yes.
On timing, if someone doesn't file against you, is that the end of your judicial candidacy for purposes of attending events?
Yes.
Okay.
You're no longer challenged. You have
Right.
no candidacy. You may have filed, but no one filed. The filing period's over. You're done. I don't think you're in a contested election. But then again, we're at the bar of what Judge Hancock or Judge Erlick may say, oh, sure, I'm still campaigning. I think you're done at the end of the filing because you have no candidate.
I guess my question is, why would you want to?
Yeah.
We can talk.
Decide this on the narrowest possible.
Yeah.
I might file a dissenting opinion, though. I think if we go to the definition of judicial candidate, it's any person who is seeking selection for or retention in judicial office. So I think from the moment you declare to the moment the election happens, you fit within the definition of a judicial candidate. Now, you might be a judicial candidate who's in, but you're still a candidate.
Theoretically, there could be a write-in, I suppose, as a possibility.
Theoretically.
Or you may want to ward off any future challenges by getting as many votes as you can, even though you know you're going to get reelected.
But in that instance, you're not going to be on the ballot.
Right.
And I think you're done, but that's back to your
No,
question.
she is on the ballot.
I would be on the ballot.
She is on the
That's
ballot.
way- Yeah.
Yeah,
because
different.
Another perverse rule.
Yeah,
Yeah.
odd.
It's
But-
It's a very interesting thing about Washington law in that regard. I come from a smaller county, and,
Right.
and we're on the ballot for the general election.
Yeah.
As well as the primary, even though we had no opponent. We have to be on both the primary and the general election ballot, because we're a county of less than 100,000 people.
So the most protective stance would be to
Interesting
stop.
twist.
Stop.
The least is not.
Yeah.
Judge Erlick talked about reimbursing yourself if you lent your campaign money
Mhm.
with the $5,500 limit.
Right.
What I'm wondering, let's say you loaned your campaign $100,000.
Right.
You ended up spending $50,000. What
Right.
do you do with the remainder?
Well, I think there's a formula that the PDC has as to where the money goes, and I know that you start with reimbursing, I think, your contributors, other contributors. So, of course, so you loaned $100,000 and you spent 50, you didn't get money from anyone else, I take it.
Maybe you did, I don't know. I mean,
Okay.
some people may want to have a big war chest starting off just to kind of scare off competition. They spend some money up front and then decide they don't draw an opposition, so they don't need to spend any more.
Right. I don't know, it's in the PDC where all that money
Okay.
goes. I know you cannot give it to other you cannot give it to other candidates. You can't use it for personal expenses. I do know that part of the formula is reimbursing your other contributors if there's surplus funds.
Can you carry it over to future potential campaigns?
I
You can,
believe you can, and you can also use it for your filing, I think.
yeah.
Okay.
You can carry it forward, but the other thing would be to be more carefully analyze your budget. And if you had the money in your savings account that you donated it as you needed it in $25,000 blocks, so that you didn't, knowing you had a $4,000 expense coming up, so that you wouldn't be with the big war chest.
Okay, and then, I'm a lawyer, so just knowing where the rules are. If someone wanted to kind of game this, would there be the ability to them retain the $100,000 and then use it as an independent expenditure of personal expression? Does that make sense? And not pump it into the campaign, but spend $100,000?
No, you can't coordinate. The independent expenditure rules does not allow coordination with the campaign. It
Are
has to
you
be-
talking constitutional issues like the McCutcheon case and things like that?
Well, I mean, I realize it ultimately gets into that, but, okay.
Don't
I
they cross
don't know the answer to that.
Well, I suppose, I don't know what the limits are for, I think there are limits that, what you could probably do, you could borrow the money from a bank. And then you can reimburse the bank with those funds. That's permitted, because I know there's a commercial loan exception.
There are citations to RCWs in the materials at tab 3, page 71 goes to the top of page 72. Being completely unencumbered by any experience, I can't tell you what they say, but at least there are citations.
And unfortunately, not having a lot in the way of surplus funds, I don't personally experience it.
I would say you'd be creating more problems than you would ever want. I know judges who have carried forward campaign contribution, war chests, but every year we have to refile our PDC, and so you have to disclose what you have in your savings account. If it's got a big E on it, they know you got a war chest, because E means $100,000 or more sitting around the savings account. So they know you have it, even though it isn't in a campaign account. It's not in a campaign account.
Just on the last part of what you were talking about, transferring it over, wouldn't that step across the line of the personal distribution of that money? Remember, you only get to give yourself back $5,500.
Right.
He's looking at over $50,000, and he's saying that can he make this decision to cross it over into something else, but that still puts his personal interest in it. Don't that cross that ethical line?
It's an exception to the $5,500 rule is what we're talking about here. It's a good question. Roger makes a good point. We do have a frequently asked question about that. As Roger pointed out, page 71 and 72 of the materials, what may be done with unspent campaign funds? It cites the statute. So
One would hope the statutes are based on ethics, but it's not as governed by the ethical rules per se.
No wonder you're number 3.
other questions, folks? Any other questions? Any no further questions? Yes, back here.
I do have a question. The statutes say that the state seal shall not be used to help elect a candidate or defeat a candidate. But in numerous websites I've seen for candidates that are sitting judges, there's typically something emblematic that shows the state seal. And I've talked to everybody, including the governor's office, on it. And the closest answer I've gotten to it is that it's never been litigated, A. And B, if it's just incidental use, even though the statute seems to be prohibited with that, it says shall not. I'm just wondering what your positions were on that particular issue.
You're talking about a statute in the state of Washington, right?
Yeah.
Okay. Interesting question. I don't know that we've addressed that previously. It's a flat prohibition, is it?
It appears to be, as I read it, to be relatively clear, but the person I talked to used some similar language that I heard from other agencies, that if it was incidental, that it was allowed or allowable, but they had no case law. And in fact, I said, well, what if I were just complaining about it? What would you do? And they said, we don't know that we do anything about it. which goes back to your comment that a complaint, it just kind of sits out there and
Well,
maybe never gets traction.
Remember the code has a very elementary provision, judges must comply with the law. So if a judge were to use the seal of the state of Washington in the campaign photograph or something like that, and I'm frankly not, at this moment familiar with the wording of this statute, but if it flatly prohibits the use of the seal of the state of Washington, that would be in violation of the law and probably unethical to do that. I think one should avoid doing that, obviously.
I would agree. I sure don't mind making new law in the state, but I sure don't want the case to be, state of Washington versus Vicki Hogan. We talk about the Ishikawa factors, gosh. Ishikawa loves that. That, you're being broiled in perhaps a controversy in the middle of a very interesting campaign, but it has nothing to do with about the qualifications of that individual to be a judge. It just would be like, my bar is really high on what I won't do in a campaign. I wouldn't use it, especially if there's a specific statute.
Most definitely.
Then how do you reconcile if you happen to be standing close to the Washington state flag, which has,
I'd be sure my steering committee was looking at the copy with me to make sure that what I released, as Mr. Wynne pointed out, we're subject to what our people do. I mean, if it went to print that way, then shame on me that I let that go, or my steering committee let that go, or my campaign chair, or my highly paid consultant.
I will agree that most of the higher profile election websites that I looked at had no indication that they were Washington state, politicians or seeking. I mean, not visually. They might say verbiage that they are, but there's no visual indicators. But some of the Supreme Court justices, I have to admit, I was able to find emblematic spots.
Well, the internet's changed a lot of things too, and, comparing what 1992 election that I had to 2012 election, 20 years later, oh my gosh, the internet's changed everything. The websites that go up that Judge Erlick referred to, it has changed a lot in terms of media release, and even that copy has to be closely watched. And Facebook, we're using all those other social medias to connect out, and they have to be part of the following the rules as well.
I will tell you, and I'm dead serious, that when you're dealing with the internet and you've got a steering committee and everything, be careful what's out there. That Facebook, social media, you have where they can come out and connect sound bites. They can turn around and manipulate pictures, and you're being held accountable for what's going out there. And you're approved for it to go out there, and somebody tweets it out there, somebody else grabs it and throw that still out there, and you just happenstance got that still out there on you. You may not want to set case law, but you may accidentally get caught up in it. So I do say, no matter what you're doing, if you have a steering committee or if you have somebody working for you or so forth, whatever, be careful to understand the rules of what's happening when social media get involved.
And that what she says is kind of consistent with what the governor's office said, that when it becomes an integrated approach versus just incidental, if they take a picture of you on the bench and happen to be the emblem, that's considered they consider that an incidental use versus a collage maybe that brought it forth. So it's interesting.
Well, it would depend on if this was something intentionally done or just incidental in the sense of some person from the media taking your photograph and the seal happens to be in it. You have no control over that. It's whether your campaign staff is doing it, which would be prohibited.
Yeah, the other question I had, a lot of the judicial campaigns, the judicial officers are also state employees or public officials. And so they're limited by the use of public resources for purposes of the campaign.
Right.
And one thing that's come up in at least one campaign I participated in was where the line is in terms of what they can do. Can they do stuff within the courthouse? Do we have to go outside the front door? Can we use the public meeting rooms in the law library? Is there any kind of standard with regard to those things? Because when I did this campaign, it was about 15 years ago, so it's been a while.
I have a vague recollection of there being that there was a challenge to judges using their robes, because the robes are public property,
Okay.
belong to the state. And I believe it was PDC said it was de minimis use. And
We actually argued that, the Ethics Advisory Committee, because it was in, they came to a different conclusion than the Ethics Advisory Committee did, and we met with them, and they came around to see that that was just
Right.
the minimus use.
you know, I think in terms of a courthouse public space for like a photograph, I think that would be open to anybody.
Yes.
And therefore, I don't think that a judge or judicial candidate would be violating anything in that respect. With respect to a meeting room, I don't think you'd use it for political purposes.
My bar is very high. Stay out of the courthouse, 8:30 to 4:30. If you want to talk on the phone, take your cell phone outside.
During campaign season in Seattle City Hall where I work, there's sort of candidates row down on the lobby, which is sort of out of the flow. We don't make people go outside and stand in the rain, but we do expect them to be out of their offices and on their own cell phone in case they had a device that's provided by the public. Do recall these are rules of reason and they're judged in context, but if you have a way to completely disassociate yourself without, say, getting pneumonia, do it, and just avoid the
Maybe similar, what would require a vacation day as opposed to not taking vacation time?
That's going to be a function probably of the local government's own policy. I know in the city of Seattle we have ethics rules about that, but that's really more of a use of city funds. But you know, again, think it through, err on the side of keeping public trust, not only because you may be a judge, but also if you are a public employee, there are ethical rules that have the same kind of canon on there. So be ready to part with some time you might otherwise want to spend relaxing.
Other questions?
Are we done?
Well, thanks all for coming in here.